Hello, dear aspiring young friend. Yes, I'm speaking to you. If you are a young law student or a young law degree holder aspiring to become a judge immediately on acquiring a law degree, the Supreme Court delivered an important judgment today. That means today, on 20 May 2025, that's a must know for every judiciary aspirant. And probably you must have known it by now. If not, then you can get the link to the news item in the description of this video. The Supreme Court restored the rule that you need 3 years of practice as an advocate to apply for judicial posts like civil judge. Now, why? Because the Supreme Court thought that having an experience as an advocate first is the necessity to becoming a good judge. The Supreme Court observed some hard truth in this judgment. For the last 20 years, they have allowed fresh law graduates become judicial officers without a single day in the court as an advocate. And you know what? It hasn't worked out well. The court said it loud and clear. Letting fresh graduates step into judicial roles has caused problems. Why? Because judges, from day one, they deal with huge responsibilities, decisions about life, liberty, property, people's reputations, their rights, duties, etc., etc. So the thing is, no matter how many law books you have read or how much pre-service training you have had, it's not enough. The Supreme Court agreed with most high courts that 3 years of this hands-on experience as an advocate is essential to make you ready for the bench. The court said that nothing beats the real-world experience of being an advocate. When you are out there practicing as an advocate, you are in the trenches, watching how courts work, seeing how lawyers argue, and learning how judges think. And you actually work. You meet clients, understand their problems, you study the law, you research the law, you think strategically to help them out, you draft pleadings, plaint, written statement, petitions, affidavits. You know the filing process and the things related to that like court fee, jurisdiction, maintainability, etc. And you cross-examine witnesses, you argue cases, you do all that is required of an advocate. And that's where you pick up the skills to handle the complexities of becoming a judge. See, as an advocate, you are not just memorizing laws, you are learning the intricacies of the courtroom. You are drafting pleadings, you are facing tough questions and understanding what is at stake for the litigants. So, dear friend, how are you looking at this judgment? Are you disappointed or are you happy? Dear young friend, don't see this as a hurdle. See it, look at it as a chance to grow, as an opportunity to grow. Spend those 3 years of actual courtroom advocacy becoming the best advocate you can be. Work on real cases, learn from senior lawyers, and soak up everything the courtroom teaches you. That experience will make you not just a judge, but a great judge. So treat this ruling only as a wake-up call. It's telling you to build a strong foundation as an advocate before chasing that judicial robe. Trust me, those 3 years of courtroom practice will shape you in many ways no exam or training ever could. So keep pushing forward. If you are a judiciary aspirant, drop a comment below. How are you planning to make the most of your advocacy years? And if you liked the video, hit that like button, subscribe, and ring the bell icon so you don't miss any updates like this. That's it for today. I'm Advocate Nahush Khobalkar signing off, and I'll meet you in the next video. Bye and take care.